case briefs, and so much more. LSData's got what you're looking for.
The United States District Court for the District of Puerto Rico heard a case in 1967, United States v. Kalish, which centered around the right to privacy and the government's retention of arrest and identification records for individuals who were not convicted of a crime. The court ultimately decided that it has the power to order the destruction of these records. Tully Kalish, a selective service registrant, had been granted a deferment from military service to complete his studies. He received an induction notice while awaiting a response from the University of Puerto Rico Law School. Kalish claimed that he notified the local board of his situation and requested a reopening of his status or a hearing, which the board allegedly refused. Kalish reported for induction but was released due to the advice of his counsel. The United States attorney arrested him, retaining his criminal identification records despite no conviction or pending charges against him. Kalish moved for an order to expunge and destroy the photographs and fingerprints taken following his voluntary submission to the court. The government opposed the motion, but after being served and argued by both parties, it was granted by the court. The court held that the Attorney General was prohibited from sharing records or identification information with any other government, agency, or individual, and required the Attorney General to promptly inform the court about the time, place, and method of records destruction. The Attorney General was to promptly inform the court about the time, place, and method of records destruction.
Case briefs, and so much more. LSData's got what you're looking for. Visit LSD.law, elevate your mind. Leave the stress of class.